Welcome everyone to our third Google Hangout. I'm here with criminal defense attorney Andrew D. Stein. Last week we spoke about a case that changed his client's life for the better. With the holidays approaching, we felt it'd be important to offer some tips about what to do and what not to do during the holidays with all the Christmas parties that potentially people will be attending. And if the unforeseen happens and you get stopped, going to and from one of these parties, what are some of the things that you should do? Andy, how are you doing today?
I'm doing well. Good afternoon, Renee.
Best of the season to you and your family.
Same to you, sir.
Andy, maybe you can tell our viewers, what would be the most important things that they should know if they're pulled over or charged with a DUI during the holidays?
Well, first of all, I think it's important to be courteous to law enforcement officers when you're stopped, whether it's the Palm Beach County Sheriffs or other local law enforcement officers. Being courteous is very important for a lot of reasons. The first reason is because most of the time, if not always, the video is going to demonstrate how you're reacting, what you're saying, what you're not saying when you're stopped. So being courteous is a very important feature for a jury or a judge to consider. The things that law enforcement need to show in the state of Florida are that you have an alcohol level greater than 0.08, or that your normal faculties are impaired while you're in physical control of an automobile. With that being said, the first thing that happens after a stop is you are asked for your driver's license, you are asked for your insurance card, and you're asked for your registration. That is being recorded by an audio system that the officer wears, and also by a video, in-car video, or a video that's in the vehicle of the police officer that radiates out to the stop itself. So be courteous, provide them with the driver's license, the insurance card, and the registration. That's mandated by law. You must give them that. After that, the officer will want to ask questions. They want to see how you react to those questions. They want to see whether you're able to act in an emergency. So after they turn on the lights, how long did it take for you to pull over? Did you pull over in a safe location? They also want to see your dexterity. They want to see your normal faculties, your ability to see, read, walk, judge distances, obviously talk, act in an emergency. So when they ask you questions, it's being recorded, audio and video. So when you're speaking, they're looking for signs of impairment like slurred speech or a thick tongue. A thick tongue is much like Daffy Duck, if you remember that cartoon, and it will pick up that on the audio. One of the other things they want to do is they're going to want to smell your breath or smell your person to see if alcohol is coming from your breath or emanating from your person. They usually do that by requesting that you get out of the vehicle or roll down your window. When they ask you to get out of your vehicle, they're going to look for signs of impairment with your inability to walk. So if you get out of the vehicle, if you stumble or if you hold on to the vehicle for balance, they're going to use that against you. One of the things that they look for also is your ability to react to questions. So if they ask you a question about what is today's date, or where are you coming from, where are you going, did you drink, I suggest that you not answer those questions. I suggest that you tell the officer that you're not going to answer those questions because you have a lawyer and you're exercising your right to a lawyer. They're also going to ask for you to do field sobriety tests. They're going to ask you to do, the first thing they usually ask is the HGN test. They basically put a light in your eye. They ask you to follow it by keeping your head still or stationary to see how your pupils react. That is a non-scientific test, but they do that to get a reaction from the light to the pupil. With that being said, I would reject those tests. I would reject the HGN, and I would tell the officer, I'm not going to do any of your tests. I'm exercising my right to a lawyer. Another test they like for you to do is finger to nose. They have you stand, put your hands on your side, and ask you to raise your finger. Usually it's right, left, and then they say left, because they get you going in the motion of right, left, and then they say left to try to trick the brain after it's been focusing on right, left, because you're automatically going to pick up your right finger and go to your nose, but they said left. So the reaction is to use your right finger. That's being videoed. So you want to reject that test also. They will then ask you to walk a straight line, heel to toe. They will tell you to take 10 steps forward, pivot, come back 10 steps. I would reject that also. The reason being is because these are professional officers who have done these tests hundreds, if not thousands of times. Not only have they done them hundreds, if not thousands of times, but they've been trained to do them. Most individuals have not been trained to do finger to nose or have been trained to do heel to toe. So I don't care if you're a professional basketball player or if you're a lay person. It's very difficult to do those tests. With that being said, a lot of times they'll ask you to tip your head back and recite the Romberg alphabet. Most people don't even know what the Romberg alphabet is. It's just the alphabet A through Z. What they're looking for is to hear your voice, your pattern, to see if you are speaking clearly. I would reject those tests also. So my advice is to reject the field sobriety test, and also if they place you in handcuffs and take you to the local BAT facility, which stands for Blood Alcohol Testing Facility, I would suggest that you not answer any of the questions there. They will put you there in a seat which is being video recorded and audio recorded at the local precinct or station, which is usually the Palm Beach County BAT facility, which is located at the Gun Club Jail. They will ask a series of questions there. They will ask your name, your address, where were you going, where were you coming from, when was the last time you consumed alcohol, if you consumed alcohol, how much, who were you with, when was the last time you have eaten, or when was the last time you had something to eat. I would suggest that you not answer any of those questions. They will then ask you to stand on an X. So it's an X on the ground, it's a tile floor, white in color, with a black X. They will have you stand there. They will then ask you to do the breathalyzer. I would ask that you not do the breathalyzer. The breathalyzer machine is a machine that's usually the intoxilizer machine. It's set up to allegedly catch the alcohol molecules that we breathe out from our lungs. With that being said, it's a long process, but basically the breath is coming out of the blood because the blood is transferred. Oxygen and carbon dioxide comes out of the blood into the lungs. Other properties in the blood come out, and then we exhale. One of the molecules is the alcohol molecule that will come out, allegedly be caught in the machine, and you'll get a rating. Anything greater than 0.08 is considered to be above the legal limit in the state of Florida if you're 21 years or older. If you're under the age of 21, then it's much lower, the level that they're looking for. I would not submit to a blood alcohol test or a breath test, because that machine is not, in my opinion and the opinion of many criminal defense lawyers, not properly calculated on many occasions. It's got built-in error. Also, it picks up particles like coming from the blood other than the alcohol particle, which will give a false test, or which will give a false result to the test provided. So I would be courteous. I would say as little as possible, and I would also not do any of the tests. And that is my advice on all DUI-related offenses in the state of Florida.
Well, that's great information. So you're courteous to the if you're listening. But anytime they ask you to do any kind of field sobriety test, it's possible to decline any of those tests after requesting an attorney.
Absolutely. Anytime the field sobriety tests are requested, you have an absolute right to refuse those.
Okay, well that's great information for anyone you know, over the holidays. I think the best advice that anybody could have is you know, if you were drinking, get a cab, you know, or call someone instead of getting into your vehicle.
Can I ask a question? Renee, let me ask a question, please. Andy, are those recommendations for only those who have been drinking? If you haven't been drinking, how should you proceed? Should you take the test, the field sobriety, or would you recommend refusing it at that point as well?
Steve, even though you may have not been drinking and you've been stopped, there's many false allegations of DUI that can result in convictions because remember, the field sobriety tests are being videotaped. Those tests are being videotaped to be used as evidence. If you don't do those tests on a daily basis, or if you don't do those tests ever in your life, it's very difficult to do those tests. Officers are not only trained on how to do them, but they've done them hundreds, if not thousands of times. So you could be completely alcohol-free, completely sober, and you can still do those tests on video and absolutely fail them. The amounts of attention and dexterity that goes into those tests are very, very difficult. Plus, understand, they are tests. So at what number do you pass? If you get 8 out of the 10 right, you get an 80%. That's passing in any college or any high school. If you get 7 out of 10 right, that's still passing. But they will consider it, law enforcement will consider it a failure because you didn't do 3 of the 10 properly. They want to see that you've done all 10 correct. You did it 100%. And that's virtually impossible for non-law enforcement or for individuals who don't do these tests on a regular basis and who have not been trained on the test, Steve. So it's not beneficial to do the test, and it's not beneficial to take a breath exam or to provide a sample of your breath because of the problems that the Intoxilyzer 5000, the Intoxilyzer 8000, and other Intoxilyzer machines that they are using throughout Florida, throughout Palm Beach County, and DUI stops. And you have an absolute right to not do those. And I think it's much better from an evidence standpoint and under a constitutional standpoint not to do those tests.
I have a question for you, Andy. If you feel like you've drank a little too much over the holidays, and God forbid you're in a vehicle and you decide to pull over, I've heard stories, and I'm not sure if this is accurate or not, but if an officer were to come by and even though your vehicle's immobile, turned off, but because you're in the vehicle, and let's say for argument's sake, they find out that you have been drinking and they start testing you. Is it better to stay in your vehicle or to be out of your vehicle in those kinds of situations?
Florida law is clear on this. If you are in the vehicle and you are possessing the vehicle, then you can be charged with DUI. If you've had too much to drink and you realize that you've had too much to drink, you need to get out of your vehicle, take the keys, put the keys in your pocket, and walk away from the vehicle to a safe location where you can make a phone call for a cab, for Uber, or for a family member or friend to pick you up. But you cannot be sitting in the car with the keys in your possession or in the ignition, even if it's turned off. I have a DUI case that just came in this week where the individual was in McDonald's. He was in the parking lot for about an hour. McDonald's employees called saying there's a suspicious vehicle. Law enforcement shows up. They find the individual in the car. The keys are in the ignition. The car is turned off. They have to knock on the window to get the individual out. He was sleepy or otherwise. and they charged him with DUI. So being in control of the vehicle means that you are in physical control of it. You're sitting in it. You have the keys either in the ignition or in your pocket. You're able to use the vehicle. If you're out of the vehicle walking away and they stop you, you do not want to make statements that you just left the vehicle or that you were in the vehicle. Do not make any statements about where you are coming or where you are going. Just exercise your right to your lawyer. I have a lawyer, and I don't want to give any statements. With that being said, it's very difficult for them to put you in the vehicle while under the influence of alcohol.
Okay, well, that's some of the best I've heard in a long time. Who are in those kinds of situations. If you've been charged with a crime in Palm Beach County, please call defense lawyer Andrew D. Stein at 561-880-4300, or you can visit the firm at www.andrewdstein.com. Again, Andy, it's always a pleasure hearing you talk about the law and advocating the way you do. Thanks again for sharing